On behalf of the coalition of organizations, I present the following closing. I'd like you to understand that at the heart of this consideration is the loss of 46 acres of mature and in some cases old growth forest, the last tract of significant forest in eastern Delaware County. The development is wrong for Marple Township, it's wrong for the people here, and it's wrong for the environment. We've presented 7 witnesses, not 8. 7 witnesses for your consideration. They provided evidence of non-compliance with the tree protection provisions of the zoning code, inadequacy of the investigation into the environmental values and resources present on the land, into the contamination that's present in certain areas, and the inadequacy of the stormwater management system, with numerous provisions found to be very questionable in terms of their compliance by our experts there as well. I will briefly summarize some of the testimony, and then I intend to, with the equal time that was granted to counsel, summarize the legal position with regard to the Environmental Rights Amendment. Our stormwater engineer, Michelle Adams, alerted you to a massive increase in runoff from the site because of this development, an extra 18 million gallons per year based on the developer's own calculations. And she noted that the DEP makes developers design a system based on a 2-year storm. You've seen from the evidence that we showed tonight that just in this past summer, we had 2 storms that significantly exceeded that 2-year storm. Ms. Adams also has very real concern about whether your regulations as they exist are going to be adequate to protect the township and downstream communities from the effects of the stormwater flows. So can you truly recommend approval? Can you truly grant approval to a development which will result in those kinds of increases in stormwater? Ms. Adams also explained that the stormwater basins on the development are inadequate, likely to function poorly based on their design, with resulting erosion and sedimentation, flooding, loss of base flow to the streams and wetlands on the property, and reduced stream quality. She also mentioned the improper assumptions by the developer's consultants regarding absorption that can be expected from lawns on the property, which she indicated are far poorer at accepting rainwater and preventing it from runoff than, of course, forest would be. Now, she indicated, and it's in the evidence, the various provisions of your stormwater ordinance that she does not believe the development is likely to comply with, and they are identified in her slides. The development is also poor planning because of the design and grading that will be implemented. As the architect and planning consultant Jay Cooperson showed, dozens of the planned units are poorly situated alongside steep slopes or swales, some of much of their basements actually situated below the level of those swales. He found that the relationship to many of these homes to the landscape is going to be awkward, and safety will be a concern. He also sees erosion and flooding to be expected in the future, and that the township certainly can be expected to be receiving the calls of angry and desperate homeowners in this development in the future while this developer has sold off and moved on. Our following witness, Rick Ray, the horticulturalist, testified to the overall health of the forest as being far better than what was portrayed in the consultant's reports. And many of the trees marked as diseased and given just a few years to live may actually live and heal themselves and live up to 50 years. He stated that the tree replacement plan necessary for this approval is non-compliant. He explained that the developer's consultant took improper exemptions from the compensation that your code requires for 266 mature trees that are slated for removal by this development. Now, without those Section 363F exemptions, the developer will need 532 additional 3-inch trees to be planted in order to satisfy the code, your code. The problem is they apparently lack the room to properly plant even the 3,200 trees that they are currently acknowledging that are necessary in that tree replacement plan they have. Mr. Ray testified to the spacing of those trees as being inadequate and anticipate a reasonable survival rate for those trees. And for that reason, the plan also cannot be deemed compliant. Lastly, Mr. Ray noted that even with 2 3-inch trees, it will take 20 years for those 2 trees to reproduce the stormwater management benefits that you would get from 1 mature tree that you're taking out. We followed that with Tim Devaney, an arborist, who informed the board about strategies available for vine removal, and he had several pieces of evidence to support his experience. He opined that the trees freed from vines, which is a fairly simple endeavor, can generally make strong recoveries, those trees. On that basis, Mr. Devaney found it entirely inappropriate under the tree protection ordinance of Marple Township for this developer to claim exemption from the 2-to-1 compensation requirement for vine-encumbered trees, which the developer's consultant numbered at 443. So without a showing that a tree is dead, and with an available remedy of simple cuts to the vine stems, those recoverable trees must be compensated for. The developer must therefore plant an additional 886 3-inch trees from that category alone. You put the trees from Mr. Ray and the trees from Mr. Devaney together, and their testimony to you is that we are over 1,200 additional trees that are required to be compensated by being planted on this property. But the problem is they're not going to be able to be compliant in that way because there's no room. 8 feet apart is already too tight, Mr. Ray has testified to. If you add 1,200 more trees, you're increasing it by more than a third. The density will increase very significantly, and that is unsustainable for the trees. So therefore, you're causing injury, and the township is taking it on the chin if they were to grant a waiver to those requirements. So we clearly do not advise you to accept the alternative force enhancement with the whips. That is a deep loss to the township in terms of stormwater benefits. But as you can see, the tree replacement plan itself is non-compliant, and on that basis alone, the board would be in a position to, a well-founded position, to deny this application. Darren LeBrake followed, and he identified many issues of concern with regard to contaminants, inadequate assessment of the contamination coming from that landfill. It's a deep concern, frankly, that the leachate has not been analyzed and testing has not been done in the groundwater below the landfill or in the streams. That is simply irresponsible, and it's not acceptable. Now, the other side says that you have no obligation and no ability to look at the waters on this property, but that's not really true. Because of the Environmental Rights Amendment, you have a duty as a municipality, as an instrumentality of the Commonwealth. You have the same duty as the state to make sure that the Environmental Rights Amendment is upheld, because you're considered a trustee of the public natural resources. And contrary to counsel's claim, the Pennsylvania Supreme Court has clearly ruled that things such as trees, things such as surface water, groundwater, flora and fauna, the wildlife, the plants, all of these things that are present on this property are considered public natural resources, regardless of whether the property itself is in private hands. And therefore, your right and your duty to protect those lands, your obligation is there, and you must carry it out. Briefly, regarding our Mr. Stein, Fred Stein presented the obligations that reminded you of your obligations under your MS4 and the pollution reduction plan to reduce by 10% the pollution loading of things such as sediment from the creeks in your township. And if you allow a development to go forward that is going to increase stormwater flow, that's going to increase erosion. We have evidence of that effect, competent evidence to that effect. And that's what you can expect, is that you're going to have a very difficult time meeting your obligations. Another reason why you should take into account a denial of this application. Dr. Schmidt finally testified to several things. He found the environmental assessment was inadequate, not up to standards of quality. He also indicated that you would expect a likely de-watering of the wetlands on this property, and that is a protected natural resource, public natural resource, those wetlands, de-watered by the basins and the stormwater collection instead of the typical natural flow of water down into those wetlands that we have now. He lastly said that there will be no baseline of data for assessing the water quality impacts of this construction because no data has been collected. Now, quickly, if I may, to the issue of the Environmental Rights Amendment. It was 2017 that in the Pennsylvania Environmental Defense Foundation case that the PA Supreme Court awakened the Environmental Rights Amendment to the Constitution, which is Article 1 of the Pennsylvania Constitution in 1971. And the way the council wants you to consider that constitutional amendment is that it essentially carries no power at all. Well, that's actually the way the law used to be before 2017, because you see, shortly after the Environmental Rights Amendment was passed, lower courts such as the Commonwealth Court established a new test under the Payne versus Kassab test, which basically said, hey, you're going to have to look at the environmental right, see if an environmental right has been violated. Just check and see. Were you able to satisfy, do you have a permit? Were you able to satisfy the requirements of an ordinance or a regulation? If you satisfied those requirements, then you're fine. There's no Environmental Rights Amendment violation. And that essentially allowed municipalities and the Department of Environmental Protection to put up whatever kind of levels of protection they wanted. It made the actual constitutional rights of persons essentially meaningless. But in 2017, that all changed because the Supreme Court explicitly overruled that Payne test. And it's going to be in my memo of law, which I'm going to send to you momentarily. With that thrown out, what happens now is you essentially have to take a constitutional analysis. Every municipality has to examine their duties under the terms of the Environmental Rights Amendment language itself. People have a right to clean air and pure water, preservation of natural, scenic, historic, and aesthetic values of the environment. The public natural resources are the common property of all people, including generations yet to come. You are the trustee under the last clause. So we ask you to consider your duties to make sure that there are no violations. And frankly, the way this has been interpreted is to say, well, we take a look to see what is being proposed. What will we allow by our action approving this development? Will the development result in an unreasonable degradation to the environment, to the rights that people have to a clean environment and to these public natural resources, which includes things as small as the invertebrate communities that hold up the water quality and are at the basis of the ecosystem in these streams that Mr. LeBrake testified to. It's all the life forms. So if you're going to take your duties as environmental, as a trustee seriously under the Constitution, then you're going to have to look at the evidence we presented, which showed you many instances of degradation that will be caused by this development. We believe those are compelling. So in addition to the fact that based on the Adams analysis on the stormwater ordinance, based on Devaney and Ray's analysis of the tree protection ordinance, this development is non-compliant if you look at it from a code perspective and at the level of municipality planning code, as Mr. Donahue would like you to do. It's non-compliant in substantial ways that you are within your rights to deny. But I'm going to tell you that there is a higher law than even the municipality's planning code, which is a statute, and that is constitutional law. So you do have a duty under the Environmental Rights Amendment to go beyond it. Now, you may not be able to create a regulatory scheme such as the DEP has created. You don't have that power, right? That's agreed. You don't have that power, but you do have a responsibility to determine, to do a pre-action analysis and determine whether or not what you're going to do is going to cause an unreasonable degradation that is a violation of the Environmental Rights Amendment. If you find that one will occur, then you are obligated to deny the application. And I suggest to you that we have presented sufficient evidence for you to come to that determination as well. And I'm just going to lastly close with the fact that this law has also been interpreted in Delaware County by the Court of Common Pleas by Judge Green in the appeal of Mutchler case, where the court decided that a pre-action analysis was necessary at the level of a subdivision and land development proposal. At the application that was before the municipality there, that was appealed to the Court of Common Pleas, and the Court of Common Pleas judged that a proper analysis of whether there was a violation of the ERA had not been performed by the municipality, and he remanded it back. And that's the law here. That's the precedent here in Delaware County. And we followed up with that. We're beyond that now to the case in Concord Township, which Mr. Donahue was the solicitor for. And he pointed out there were other violations of the code, and that may well be. But there's no question that the findings of fact and conclusions of law that he submitted to decide that case specifically referenced violations of the Environmental Rights Amendment as part of the basis for the decision to deny that development. And it's really the same thing here, but Mr. Donahue is in a different role in this position. So I ask you to consider your duty very seriously under the Environmental Rights Amendment and conclude in a way that Mr. Donahue, as solicitor, concluded in Concord Township. So respectfully, I do urge you, don't recommend approval. Don't recommend. Keep in mind that your own planning commission could not recommend approval of this development, and particularly with regard to the tree protection ordinance noncompliance. They did not recommend it to you. So take that into account, and I do ask you and I urge you to deny this application. Thank you very much for your indulgence on this, and at this time, I will be submitting my memorandum of law, where you can see all of the permutations of that Supreme Court case and others. Thank you.